Ladies and gentlemen, I present to you a lawyer who takes responsibility, who makes commitments to his community and profession, and who embodies Cooley's mission that an outstanding lawyer must have knowledge, skills, and ethics. Today's speaker, Mr. Jack C. Davis.
Good afternoon. That was quite an introduction. I can't wait to hear what I have to say. Cooley President LeDuc, distinguished members of the Board of Directors, learned members of the faculty, members of the Livingston Class of Cooley, parents, grandparents, husbands, wives, relatives, and friends. I want to thank President LeDuc for asking me to speak this afternoon. I am very honored to be here today. Our community has watched Cooley grow from its simple beginnings, as conceptualized by Justice Brennan, to become the largest law school in the country, with faculty members recognized as the most outstanding in the nation, and graduates who have leadership roles in law and in other professions throughout the nation. This is truly an inspiring story. You have studied hard. You have disciplined yourself to put in extraordinary time and energy to prepare for and participate in class. You have gained appreciation for the role of logic and analytical reasoning in the thought process, and the emphasis on analytical reasoning has changed you as a person. Congratulations. Where do you go from here? You may have been thinking private practice, perhaps on your own or with a law firm. You may have been thinking of becoming an institutional professional, either with a private company or a public agency. You may be thinking there are few opportunities in private practice and you can be more successful in another career. We hear criticism of law schools that graduates do not find enough opportunities in the legal profession and have to find opportunity in other professions such as insurance, public administration, corporate administration, or social non-profit causes. I can tell you that I went to Harvard Law School to be exposed to an experience that would be a useful step in my career, whatever that career might be. I was not particularly interested in a career as a practicing lawyer. That is why I don't understand the criticism when a law school graduate does not end up in private practice. Law school is for preparation. It is for fine-tuning your thinking process. It is for learning how to approach and successfully analyze problems and challenges. It is to prepare you for a career, but not necessarily in private practice. I don't consider law school as a trade school, but it is to learn the fundamentals of our legal system, which is the backbone of our democracy, and which is at the core of any commercial or social activity. It is this knowledge of the legal system and appreciation of rationality and logic that prepares you for a career in our society, whatever that career might be. Now that you are graduating, what characteristics do you need to be successful in private practice or another career path? Cooley works hard to prepare you and goes out of the way to make you aware of the real world by encouraging you to participate in clinics and also by way of its excellent externship program. It is my intent in these remarks to comment on what you will face in the future from my experience of 50 years as a lawyer and dealing with all aspects of the world of commerce and the community as a whole. I should also let you know that our firm has hired several Cooley graduates, and they have been very well prepared and important additions to our staff. Our current firm president is a Cooley graduate. To prepare for these remarks, I asked them for suggestions as to what they could have used as advice when they began their careers. So much of what I have to say is based on their input. First, consider whether you're well suited for a career with a large organization or a small-scale entrepreneurial career. I started out from law school with the largest law firm in the Midwest, in Chicago. By the way, my wage and the normal wage for a Harvard Law School graduate in 1964 was $7,200 a year. After 1 year, the salary was raised to $7,800 a year. You can see how times have changed, but please keep in mind you could buy a Chevrolet for $2,200, and you could buy a middle-class type home for $15,000. In this law firm, I was assigned to a particular department specializing in state and local taxation. I began to understand that I was not particularly good at succeeding in a large organization. Since in a large organization, you may be instructed to follow an avenue of approach that you don't fully understand or don't agree with. Sometimes you're allowed to be heard on the matter, and sometimes not. I am not good at fitting into a plan that I don't fully understand. I considered relocating to my hometown of Lansing. I knew many members of the community and felt I could build a practice. George Loomis of the Loomis Law firm, where I still practice, hired me at the same $7,800. And for a few years, I worked on his utility client cases. My billing rate at the beginning was $15 an hour. I started to network with medical professionals and real estate development entrepreneurs and began to have them engage me as their attorney. My first client I met in the military reserves at the Marshall Street Armory here in Lansing. In those days, most everybody had to serve in the military, as there was a draft, and he and I served in the military as graduates of ROTC. My second client was referred to me by an insurance salesman that I had known in high school. My third client was a graduate from the construction school at Michigan State University who wanted to build apartment projects. I met him at a New Year's Eve party. He still develops projects, and I still represent him, and he's probably calling me on the cell phone right now. And we just went to the Rose Bowl together. In any event, after 5 years, I didn't need support from other firm clients and had developed a practice of my own. So what can we learn from my experience? First, know yourself. You must evaluate your strengths and weaknesses. I was the Michigan State debate champion my senior year in high school, so I thought I could do well in competitive litigation. As I practiced law, I also found that I had a talent advising as to entrepreneurship, which is basically perceiving an economic opportunity and developing a business plan to make it lead to financial success. Secondly, I learned there are 3 basic ways to develop a legal practice, and these are not mutually exclusive. 1, take an assignment from an established lawyer, a mentor, such as George Loomis in my case. Then have the mentor teach every aspect of the practice as you work with him. Of course, with the Loomis Law firm having only 10 attorneys at the time, I could thoroughly examine strategy with George Loomis, and he would discuss with me my thoughts and observations. I felt this was very different from my experience in Chicago. Another way is to become an expert in a specialized area of law, so the clients come to you because of your ability to give them expert guidance that they can't get from other lawyers. George Loomis, my mentor, started practicing law in the private sector after he had worked with the Michigan State Attorney General in the department that regulated utilities. After a few years working in that department, he felt he could be successful in advising utilities on how to deal with the regulators. Utility clients came to him because he clearly was an expert on how to best deal with state regulators. Once you have established yourself as an expert in a particular field, shout it out loudly on various internet sites. To network in the community, this is a third way of developing a practice. Networking in the community. Developing relationships with potential clients, where these potential clients can relate to you as a person and learn to connect to and trust you with issues of concern to them on either a personal or business basis. It is not particularly advisable to go into the community or other group activities with the primary motivation being to build a law practice. And it is most important that you are in a networking relationship where you have a sincere interest. If you like to hunt and fish, why, there's, of course, conservation groups or Ducks Unlimited. If you're fond of animals, Humane Society or Audubon Society. If you have an interest in business activities, the Chamber of Commerce. If you're interested in improving the lives of at-risk families, there's the Boys and Girls Club, and there's Big Brothers, Big Sisters. If you like cultural activities, you can join a support group for your cultural centers, such as on this campus, Wharton Center. In these organizations, you can develop relationships. You can gain respect from others for your thought process, your sense of commitment, and your demeanor in a variety of circumstances. This leads to mutual respect and relationships with others where they feel you can be trusted with personal and business legal issues. So if you want to enter the private practice of law, the message is examine your strengths and weaknesses and decide on which of these paths is likely to lead to success, and you may choose more than one. Next, as a lawyer, you are an advocate. This is often emphasized as being the great attribute of the profession. The rights and points of view of those who otherwise would not be heard or protected in our society are protected by courageous legal advocacy. I think this is a major positive attribute of the legal profession, and advocating for those who otherwise would not have a voice is an important characteristic of our profession. On the other hand, the reason why I was not sure I wanted to be a lawyer in private practice was because a lawyer finds that he or she is asked to advocate for some points of view that are very troublesome. For example, it is not the lawyer who walks through a subdivision with a loaded gun and shoots a young person because it is thought that a certain state statute will be protective in finding the activity was self-defense. It is not the lawyer who decides to merge with a competitor controlling 60% of the market in a particular industry, taking the position that it is allowed under the antitrust laws. It is not the lawyer that sells pharmaceuticals promoting positive effects of a product to cure high blood pressure without mentioning the fact that using the product for 5 years can bring about severe kidney damage requiring constant dialysis treatment. The point is that you will find yourself as a practicing lawyer supporting and advocating for conduct that you personally don't agree with. You will have to decide time and time again as a practicing lawyer to what extent you want to commit time and energy to vigorously advocate in support of conduct that you believe to be questionable in nature. In my case, I try not to take troublesome situations. But once you take on a client on an issue you are comfortable with, it is possible that same client will expect an excellent result, where the factual result is bothersome. For example, the client may have been served with legal process in a workplace injury case, and the staff doesn't timely send the notice to the insurance carrier for defense. A default is entered. Very irresponsible conduct by the staff. But you are supposed to figure out how to advocate so the default is set aside. Next, you will become cognizant in the practice of law of the overriding significance of the facts and circumstances behind an issue. Many times the law is clear and both sides agree on the applicable law. Nevertheless, the dispute rages on how to analyze the facts of the dispute. This requires you to be tireless in investigating the details of the event. In the law practice, you have to be an expert on legal research, but to be successful, you also have to be the most expert on the facts. This can be done by your own investigation, by investigation of those in your employ, or by learning of the complications from an expert in the field. It has historically been thought that larger law firms have a significant advantage over smaller firm practitioners in having ample, capable staffing in legal research and uncovering factual details. This is probably true, but the internet is aiding the smaller firms in closing that gap. More and more large firms are contracting out research to less expensive practitioners who largely rely on information and research gained through the internet. In your career, you're going to have to outwork the opposition in the practice of law or in any other career. It may be the main issue revolves around legal interpretation or factual analysis or both. No matter, the best result in the end is not necessarily going to the professional who did best on the LSATs or who got the best grades in law school. Success will go to the one who is tireless in trying to outsmart the opposition. Outsmart does not necessarily mean academic excellence. It also includes being more clever in setting up the facts to better fit the controlling legal principles. Or it may mean working harder at finding and distinguishing legal precedent. If your state doesn't have a case on point, find one in another state. Find one in federal court, or find something in a law review article. Do not rest until you have an angle of attack more persuasive than your opposition. A perfect example happened last week. An opponent had filed a motion and we responded. Our cited cases seemed to present the best controlling law on the subject. After these filings, 2 weeks went by before the hearing. The lawyer who made the motion never filed a reply brief to distinguish our cases. We therefore know that this was not a difficult opponent who was committed to winning. That lawyer represented the most dominant company in this particular industry. This is the practical part of being a professional lawyer. Some are in it for the paycheck, and some are in it to work hard and compete to win. By the way, my comments are not just for litigating lawyers. The same principles apply for contract negotiations and other business issues. You must be confident you are aware of all the complications that can arise and how you are dealing with them to protect your client, even in a contract negotiation. The next important point is to be careful in taking cases. If a case is extremely difficult, make sure the client knows of the difficulty. And do enough research that you know the path you plan to take to get the best possible result. In any event, tell the client the truth about the likely outcome. Many times in the early stages, you need to make it clear the outcome will be dependent on extensive investigation that will occur after you take the case. If you take the case without fully advising the client on the most likely result, then you will lose integrity with that client. You must be clear about the likely outcome, the unknowns at the time, and the possible cost of success, both in personal anxiety and in financial cost. The client will come to you absolutely convinced that he or she is entitled to a certain result on account of a personal wrong or business dealing. If you have doubts about that result, you must be honest about it. Don't lead the client into being hopeful about a result that you don't really think you can achieve. That is a lack of integrity. One aspect of integrity is the role that your compensation plays in your representation. Once you take a case, you must continue to be committed to a favorable result, regardless of the necessity of getting paid. Of course, this is your responsibility. You will need to make appropriate arrangements when taking the case. But if the client lacks integrity in meeting financial obligations, this does not excuse your total commitment until the case is over or until you properly resign for the representation. On relationships with clients, the community, judges, associates, you must be seen as having integrity. If you are giving an explanation to a client, judge, or business associate, and you are wandering from the truth, you are undercutting your long-term success. The next point, you need to remember not to burn your bridges. I can't tell you how many times I've had a position in opposition to another person or entity where several years later it was in my best interest to collaborate and or partner with that same person or entity. In handling disputes, there must be honesty, but also to the greatest extent possible, a framework of mutual respect. If you are in the habit of deprecating the other side in a dispute, just remember you may need a positive relationship with the other side in the future. The person on the other side may be a potential client, a referral source, and also may become a judge. In my experience, one of the best ways to have a person take you on as an attorney is to have dealt with them in the past where they are represented by another attorney. If you demonstrate in litigation or in negotiations that the attorney the person had hired was not up to your skill level, then you might end up with a client in another matter. Much of this discussion may seem to be applicable to those of you who are considering becoming litigators, but you may not have the aptitude for litigation. You may be better at relationship building than contesting. You may be someone who researches well, but has limited oratorical skills. You may want to emphasize family and only put in 8 hours per day in the workplace. The important thing is to, at this time, evaluate your talents, your skills, your commitment, your motivation. Choose to go in the direction that best suits your character traits. You may or may not have those characteristics suitable for the classic competitive legal profession. But fortunately, there are many more avenues open for you. Know yourself. Know your capabilities. All I'm trying to say is don't try to fool yourself. Go in the direction your skills lead you. If you don't have the motivation for outworking and outcompeting an opponent, go into a field where collaboration or social betterment is the goal. Obviously, one career path is not better than the other. Take control of your future. You will be better off if you do it now. Finally, be proud of what you've accomplished in graduating from Cooley Law School. You are better equipped than others in our society to analyze problems and using logical reasoning. You know the basis of how our economy functions. You have studied, you have analyzed, and your points of view and thought process have been tested time and time again by Cooley faculty and your fellow students. Our firm has hired many Cooley graduates. I know you are prepared. Now go out there on your career path and realize fully on your potential. Thank you.